Perfect. So are you able to continue with that, Hannah?
Yeah.
Excellent. Thank you very much. Sorry for the delay, everyone.
It's okay. It's okay. Right. Well, we'll get started now. Then. Okay. Well, good morning, everyone. Sorry for our slight delay. It's only a couple of minutes. It's all good. And on behalf of our chamber, I'd like to give you a very warm welcome to our webinar today, which is on the topic of employment issues in the new normal, which we're really happy to be holding in collaboration with Cripps Pemberton Greenish, which is one of the country's leading legal practices serving corporate, real estate and private clients, and they're also members of the Spanish Chamber of Commerce. So I'll just now briefly introduce our two speakers that we have joining us today. So we're joined by Melanie, who is a partner at Cripps Pemberton Greenish's employment team. With over 21 years experience, Melanie advises businesses, senior executives and the self-employed on a range of employment matters, including terminations, boardroom disputes and high-value tribunal claims. She regularly advises clients about the impact of COVID-19 and has been the expert contributor on Radio 5 Live, speaking of the experiences of clients in the IT, technology, financial services and retail sectors. Melanie is also part of the Employment Lawyers Association Legislative and Policy Committee, consulting on new legislation. We're also joined by Ed Dickinson, who is an associate working alongside Melanie in Cripps's employment team. He advises businesses on redundancies, terminations, HR support and contentious matters. He's a regular contributor to the firm's #Brave Future Hub, set up to provide support to businesses as they navigate through the pandemic. So following on from the speakers' presentations today, you'll have the opportunity to ask them any questions that you might have, which you can do via either the chat or the Q&A function that you can see at the bottom, on the bottom panel of your screens right there. Okay, perfect. Well, I'll now hand over to you then, Melanie.
Thanks ever so much, Hannah. We are delighted to be with the Spanish Chamber this morning. Our topic is the new normal, and we're going to talk about 5 top employment issues as businesses plan for the end of lockdown and, more importantly, hopefully, the return to normality. So if we go to the next slide, our agenda today is talking about returning to work, health and safety and other concerns. Then we're dealing with the renegotiation of contracts, where you're introducing flexible and hybrid working. We're going to talk about furlough leave extension, whether you can require your staff to be vaccinated, and then the impact of the Uber decision and IR35. So if I can kick off by talking in the next slide on the return to normality and return to work concerns. We've now been in lockdown for over a year, and on the 22nd of February, the government gave us a roadmap for easing the restrictions and a return to normal. Part of that was from the 12th of April, there would be a reopening of non-essential retail. And we are hoping that from the 17th of May at the earliest, all but the highest risk sectors will reopen for business as normal.
Melanie, do you mind if I just interrupt you quickly? I think the slides are on the not on full screen mode.
Okay. I shall try to resume the share. Can you see the slideshow?
Perfect. I think that looks like the one.
Thanks, Ed.
That's perfect.
Okay.
Yeah.
So the main concern with the return is obviously health and safety. And the government has made it clear that in that context, they're going to review their current guidance, which is to work from home, not until the 17th of May. Until then, they say working from home should continue wherever possible. And we are hopeful that from the 21st of June, the government will remove all limits, although the government has been very clear that COVID is to remain a part of our lives. So health and safety is the current priority. And in that context, as a business, you have to recall your duty of care to your staff. This is when they are at work on your premises, at work at home, and also when they are commuting to work. And the first thing to obviously take care of is to update any risk assessments that you have done. You want to ensure that you update them as to all the steps you have been taking to ensure that people are socially distant, that you have frequent cleaning, you have adequate ventilation, you have good hand hygiene, screens, rotating teams. One of the things that's been very energizing the press has been testing. And the government has been very clear that they are encouraging staff to be tested before they return to work. For any staff that are showing symptoms, they will be able to obtain rapid flow tests entirely freely from the government. And for staff where they are asymptomatic or they don't have any indication that they might have the virus, it's still possible for larger employers to obtain rapid flow tests so they can test staff that way or by a temperature test before returning to work. And Ed is going to touch later on vaccination, which I know is a very hot topic. So what do you do first? Well, having done your risk assessment, you need to publish that. Usually it will be featured on your intranet. And then you need to consult with staff. You need to talk to them about all the steps you're taking, because as you reassure them that they have a safe place of work, you are encouraging them to come back to that place of work. Do think about their travel to and from work. It may be you could restructure their hours so that they are travelling outside of peak periods, or that you could provide more car parking or access to bike loan schemes. Staff may be looking for a phased return, particularly those who are under 50 who haven't had their second or even their first sometimes vaccine. And then you might want to think about them continuing to work remotely or putting them on furlough scheme. And we're going to talk through those options. But do remember that at the moment, the government guidance is that staff should only travel where it is essential, and that staff should not come to work if they or anyone in their household is displaying symptoms of the virus. So looking at the return to normality, we know that the government has given 14 different guides for specific sectoral workplaces. So that's your starting point for all the granular detail of the things that you need to do. We know that government has indicated that they want to ensure it's essential travel only, and that face covering should be used wherever you are in contact or wherever individuals are in contact with the public. Staff who may have concerns could be raising them because they have their own concerns, or it could relate to the fact that they are dealing with somebody in their household who is more vulnerable. And I think you want to find out that information. You want to give them information and reassure them of all the steps that you are taking. Dealing with a refusal to return to the workplace, you have many, many options as a business. As we come into the summer months, many more staff will want to take holiday or furlough. They might be prepared to take the reduction in salary to go on the furlough scheme, or even unpaid leave. And in this context, do remember that anybody who has a dependent, where there is an emergency, so it's an unforeseen event like getting COVID, they would have the right to take unpaid dependent care leave, and they don't need your permission or agreement for that. Many of the businesses that we're advising at the moment have been dealt or have been faced with employees who are not keen to return to work. But taking disciplinary action has been their rare response. In most situations, they've tried to work with the individuals to get the most out of them and allay their concerns. It is open to you, if you have taken every step that you could to provide a safe workplace, to say, well, hold on, this is a reasonable instruction that you are not obeying. And then you could warn them, or in the most severe circumstances of a refusal, you could consider dismissal. But that might well cause problems. The rule is that if somebody has raised a serious and imminent concern about their own health and safety or that of others, then it potentially could be an unfair dismissal to remove them. So bear that in mind. Also, if they have particular circumstances, they are pregnant, or they have a health condition which makes them very vulnerable and could be a disability, you could then face a discrimination claim in the event that you've taken action against them. I want to talk about renegotiating contracts secondly, because we know that after a year of lockdown, 73% of employees have told a research group called Work After Lockdown that they prefer the flexibility and control that they have from their current working patterns. The government, however, has demonstrated different intentions. They have said, at Boris Johnson particularly, that he wants to see the cities full of buzz again. So where does this leave hybrid working? Many individuals may already work flexibly, and hybrid working is really only the combination of home working and office working. It's become popular amongst many large businesses. Nationwide have even said they're not going to have any offices, so they're going to combine working in a very different way. But British Airways and BP have both said that it's shown a success in lockdown, and therefore they're going to continue remote and hybrid working. So do you need a new contract? Well, I can just hear that. So do you need a new contract? Well, it's advisable to have a notification in writing of any change of a legal term of a contract. The most important thing to bear in mind here is whether you're going to do this on a temporary, perhaps trial basis, or whether it's going to be a permanent change. And for permanent changes, we'd certainly recommend that you start looking at a new contract. These might be needed where there's a change to a workplace, a change to working hours, or new issues to be dealt with in the contract that you previously hadn't thought of. You might have to deal with the security of information, or what happens to the equipment if the relationship breaks down. How do you get it back? Who's going to be responsible for ensuring it's insured? And also, what happens to the extra expenses, broadband, or any equipment, printer paper, that sort of thing. So moving on, I'd like to just talk about the existing right for staff to ask to work flexibly. And I've highlighted here that it is a right to request to work flexibly. It's not a right to have that request granted. And many staff are perhaps seeing it as a right to absolutely work as they want to work. Only certain employees have this right. They have the right if they've worked for 26 weeks, and they provide a request in writing detailing not only the change that they'd like, but how it will affect the business and how that effect can be addressed. As an employer, you need to give a reasonable consideration to that decision. Gone of the old days when you had to reply within 21 days and hold a meeting within 14 days and things like that. No, the position is now that you have to think about it and provide a reply in writing within a 3-month time limit. And there are 7 business reasons that you can refuse that. It might be that the individual wants to work at a time where there's insufficient work for them. They might have an adverse effect on their performance if they work as they intend. It might affect your costs. You might have to bring in other cover. These are amongst many of the reasons that you could use to legitimately and lawfully say, we can't accommodate that. Many businesses that we're dealing with are considering the request and looking at what could work, and often trying to find a compromise which is introduced on a trial basis. Now, the government has signalled that they are going to bring in a new right to work flexibly. They've told us that there will be a new employment bill in 2021, which will make hybrid and flexible working the default. Now, that's interesting because it doesn't exactly fit with their intention to get everybody back into the offices and the cities again. The government has indicated that they will be consulting publicly about the impact of flexible working being the default. And it's likely to be after a period when the individual has been under probation and succeeded. It's likely to deal with well-being training and management on how to deal with staff who could be isolated if they work on a hybrid pattern. It will also cover flexible incentives, financial incentives for the staff who are working from home, perhaps covering their broadband and other costs. And importantly, the rule, often introduced in other countries in Europe, the right to disconnect. the right to log off and disengage. The impact of this is likely to be that the employment bill doesn't become an employment law in 2021, or at least not until the very end. But you do need to watch this space because you need to think about the consequences for you. And what are the risks? Well, I don't quite agree with Rishi Sunak that people are going to start leaving their workplace if they're not allowed to go back in the office. But I do think that many businesses we're talking to are concerned about how they supervise and support their staff. Particularly for junior staff, they're concerned about how they monitor and train them and involve them in part of the community at work. The lockdown has shown that output and efficiency has not dipped on the whole during the lockdown period and working from home. In fact, particularly in financial services and in other services where they have clear KPIs, people have been actually more productive. Businesses, particularly in financial services, have decided to give up their fixed spaces, and there is the risk that they might be thinking about pay reductions. But I'd caution against this, because reducing somebody's salary would, of course, be a breach of their contract. I've already talked about people working from home and having extra costs. If you're providing office equipment, you also need to make sure that you are insured and able to get that back. And there are health, safety and well-being issues, which goes back to the risk assessments I talked about at the start. If you have staff that are working from home, it's going to be much more difficult to detect virtually whether they are isolated, have mental health concerns, and particularly whether they have suffered domestic violence, which we know has been an issue in lockdown. And lastly, the risks include confidentiality breaches. The information that you have on your systems, you do not want shared by being in a shared space. You do not want any issue about data having been published or processed in a way it could be obtained by other people. So you have to think about the practicalities. How do you keep things safe with double authentication, with shredding options available to staff? So with that, I'm going to hand over to Ed. Thanks, Ed.
Thanks, Melanie. As I'm sure many of you are aware, last month the government revealed that the furlough scheme would be extended to 30th of September 2021. Now, the scheme, which has been in place for over a year now, has been largely successful in preventing job losses across most industries. The scheme is going to continue as normal until 30th of June, with the government paying 80% of employees' wages, subject to a cap of £2,500 per month. And it's going to gradually taper off. So from 1st of July to 31st of July, the government contribution will be 70% and the employer will be required to pay 10%. And then from 1st of August to the end of the scheme on the 30th of September, the government contribution will be 60% and the employer will be required to pay 20%. Now, the scheme is going to continue as it has been in the sense that employers must continue to pay employers' national insurance contributions and pensions contributions. And employers are still entitled, if they wish, to top up furlough rates up to 100% of the employee's usual salary. Now, importantly, going forward, flexible furlough is going to remain an option. So as hopefully things open up, employers may choose to have some employees on flexible furloughs, meaning they can potentially work 1 week on furlough for a week, or even a couple of days of furlough and the remainder of the week on flexible furlough. Now, in terms of eligibility, from 1st of May, an employee can be put on furlough provided they have been an employee registered with HMRC, so they've been paid a salary effectively, prior to the 2nd of March 2021. So what this means in practice is that new hires from 2nd of March will not be eligible for the scheme. Now, practically speaking, written furlough agreements are still recommended and should be used. And going forward, these agreements should be reviewed and updated, particularly as contributions may change over time. And we can, of course, assist with that should you need any help with written furlough agreements. So the big question is what happens next after the scheme ends on 30th of September. And as we've seen over the past year, there have been lots of potential transitionary schemes to be put in place, but furlough has just kept on being extended. But it's all very uncertain and nothing currently is planned. It all depends on the success of the vaccination rollout and infection rates. It's very unlikely that there will be a job retention bonus scheme, which was previously touted to replace the old furlough scheme, whereby employers would receive £1,000 from the government as a bonus to retain employees for a period after furlough. We think that scheme has now seen its day, so that won't be in place, we don't think. Another scheme that the government had previously touted was the Job Support Scheme, which previously was going to replace the furlough scheme and would effectively the government would contribute 2/3 of employees' wages for unpaid periods. So when they weren't in work, up to a certain cap, and provided that those employees would still work 20% of their usual hours. Now, we feel it's unlikely that there will be transitionary support, and the reasons are, it's important to bear in mind the context of the economy and the timing of the government's roadmap. Now, under the government's roadmap, for opening up the economy, with hospitality being eased and lockdown restrictions being relaxed. As a reminder, on the 17th of May, it's planned that indoor hospitality will open up. And then on 21st of June, all limits on social distancing and social contact are going to be removed. Now, these dates are all subject to COVID and what happens. But what that potentially means is from between 21st of June and 30th of September, when the furlough scheme would end, hopefully there's enough of a buffer where furlough remains a viable option for businesses while the economy picks up. And certainly Primark released interesting news a couple of days ago with excellent data showing that they do see signs of a positive recovery. So in reality, it's unlikely that a scheme is going to be replacing furlough after 30th September, subject to how the vaccination scheme rolls out. And that leads me on to my next slide. In terms of vaccination, it's a very topical issue at the moment. Can you require staff to be vaccinated? The short answer is no, you can't. Currently, there's no statutory provision allowing the government or employers to lawfully compel employees to take a vaccine, or justifying subjecting them to a detriment if they refuse to take a vaccine. Now, some of your contracts might include a medical examinations clause, i.e., which would enable you to require employees to have a medical examination. Now, it's unlikely that such clauses would be enforceable, as employees still need to provide freely given consent to having medical procedures. So the legal risks of having a compulsory vaccination policy or a policy based on a phased return to work based on vaccination status, it poses two considerable legal risks, and it would be relevant if you were to dismiss an employee or subject them to a detriment for refusing to have a vaccine. Now, the first potential claim would be constructive unfair dismissal, which would be, or unfair dismissal, which would be applicable to employees with more than 2 years service. And in such event, the reasons you might give for dismissal would be some other substantial reason for failure to follow a business instruction. Now, it's uncertain at the moment, but it's likely to be difficult to defend a claim if it was brought on the basis of current government guidance and ACAS guidance, which suggests you cannot compel employees to have a vaccine. And an employment tribunal would also factor in the potential human rights argument that vaccinations would be a breach to privacy. And in any event, before dismissing an employee, an employer ought to have or consider alternatives to dismissal, and that there will be clearly other options, such as potentially working from home if viable, or implementing other safety measures, or even redeployment into another area of the business. So it's likely that an unfair dismissal claim could succeed. Now, another big element or risk to consider is discrimination. If an employee, worker, or contractor has a protected characteristic under the Equality Act, they, regardless of length of service, they may well be able to bring a claim. Now, again, it's uncertain what those claims might be, but we foresee a risk in particular with age discrimination, given that young people haven't had an opportunity to have vaccinations. Also, pregnant people are currently not advised to have vaccinations for their safety. And certain disabled people may, as a result of their conditions, not be advised to have a vaccine. Now, there's another potential risk, but it's a lower risk in religious or philosophical belief claims. But based on current statistics and data with regards to what vaccinations consist of, it's unlikely that such claims would be successful. But that doesn't say that an employee couldn't argue and bring a claim, so it could still be costly to defend it. Now, is there a defence to such claims? Well, an employer would need to have justification, and any policy would need to be a proportionate means of achieving a legitimate aim. Now, the first consideration, which we think might be a valid justification, would be where businesses have necessary business travel, or employees are required to travel overseas, and immigration rules stipulate that employees or individuals traveling must have vaccinations. So in that limited circumstance, there may be justification in such policy. Now, in the news at the moment, there's a big push towards or argument about the potential health and safety justification, so the health and safety of the workforce and customers. Now, we think that it's unlikely this would be a valid justification, and it will only apply in very limited circumstances, such as businesses in the healthcare industry providing services to the vulnerable, where they're clearly at risk, and there may be a proportionate justification for any measures. And linked to that, given businesses have operated without most staff being vaccinated to date, if you were now to say to employees that they were required to have vaccinations in order to be safe at work, you're potentially opening yourself up to liability by implying that your previous and current practices aren't safe. So it's a very risky area. There are other considerations related to data protection, which we can discuss if needed during questions. But in essence, collecting data for purely monitoring purposes is unlikely to be justifiable. And there are considerations under the GDPR with regards to having a specific legitimate reason for holding and retaining data. Now, practically speaking, we recommend your contracts and policies are updated in line with ACAS guidance, which stipulates that you should be encouraging employees to have vaccinations rather than forcing them to, and potentially adding incentives. So perhaps think about enabling employees to have paid leave while they have vaccinations, and even whilst on, if any employees become unwell, they are entitled to full pay for such a period. Now, we recommend having a vaccinations policy if you haven't already got one, or including wording to such effect, setting out the company's stance on vaccinations, and also stipulating that workplace testing for COVID may be required. Now, this is much less invasive than forcing employees to have a vaccine, and it sits alongside government guidance, and particularly since employers can claim free tests. So it's a very useful measure of ensuring that your staff are at work and are being safe. Now, there is an HR risk potentially going forward to consider, with disputes between employees about vaccinations, especially if an employee is particularly sensitive to having a vaccination, and another colleague or his or her colleagues don't have a vaccination, potentially if they have a vulnerable relative. Now, in a policy, you would recommend requesting employees not discuss vaccination status, and if they did, it might lead to disciplinary action. And we'd also recommend regularly providing accurate information to mitigate employees any risk of any disputes and rumours being spread, particularly with all the conspiracy rumours that are going around at the moment in the press. So in conclusion, as Melanie stated earlier, that the first port of call is to do a risk assessment to establish whether or not you need to introduce any measures. Your duty is to provide a safe place of work, but we feel that requiring vaccination is very risky, and instead you should inform and encourage employees about what the benefits of vaccinations. So I'll now hand back to Melanie, who's going to discuss the recent Uber case with you all.
Thanks, Ed. 6 weeks ago, the government's highest court, the Supreme Court in the United Kingdom, gave a decision which applies to everybody who engages with individuals who they call contractors or consultants. The two drivers for Uber were considered self-employed contractors, but the court said no. The reality of the relationship is that these two drivers are really workers, and they have the rights, the employment rights of workers. The relevance for us is that in our businesses, where we have individuals working for us who are considered self-employed, who are considered contractors or consultants, we may have to rethink according to the tests that the Supreme Court adopted. They looked at three key things. Were the individuals dependent on the business to get their work? And did they have to accept the work when it was provided? Did the individuals work under the control? Were they subordinate to the business? And here they found very much so. Uber had controlled when they worked, the terms, the fare, the contact that they had with their passengers. So if there's an element of control, then there is a risk that individuals working for us too will be called workers. And lastly, they focused on personal service. If an individual has to give their work themselves and they can't send a substitute, will the individual then be regarded as a worker? And it is very much more likely after the Uber decision. Now, the changes that Uber have made will give you an indication of the cost to your business if a relationship you have now is considered one where the person is a worker. They're entitled to the national living wage. That's a minimum of £8.91 an hour for hours worked. They're entitled to holiday pay, 5.6 weeks of paid leave per annum for somebody who works the equivalent of full-time hours. they're entitled to breaks, 20 minutes in any 6 hours, and then 11 hours in any 24-hour period. And another direct financial cost, pensions. Workers may well have to be enrolled in a workplace pension and paid up to 3% of their salary. Now, Uber have gone beyond the legal requirement in providing insurance for sickness and injury. But one thing that Uber haven't done is to pay waiting time for their drivers. And this is important. Francis O'Grady of the TUC has said that Uber is cherry picking from the decision of the Supreme Court. And that Supreme Court decision was very clear that from a moment an individual is ready to work and clocks on, they have to be paid the living wage, whether they're performing work or not. So my last slide is just talking about the impact of that Uber decision further. We know that from the 6th of April this year, the private sector had to comply with IR35, otherwise known as the off-payroll working requirements. The idea was to prevent tax avoidance and so-called disguised employment. And what's clear is that some self-employed individuals, the consultants and contractors I've been talking about, must now be taxed as an employee. The result of the Uber decision is that if somebody is controlled, if somebody is subordinate, and if somebody is working personally, then that contractor might well now fall within IR35. So what do you as a business have to do? Well, if you're a medium or large business that engages individuals through an intermediary company, every time that you engage somebody as a contractor or consultant, you now have to determine their status. And for tax purposes, there are only two possibilities. That individual worker can either be an employee for tax purposes or self-employed for tax purposes. There isn't any middle worker status that we've been talking about from the Uber decision. In Q1, most of our clients have been busily providing the status determination statements required. And we're now starting to see the challenges to those from individuals who don't want to be regarded as an employee for tax purposes. If you are an employee for tax purposes, then you need to be put on the payroll. That's an indirect cost. The business would then have to deduct income tax and national insurance from that daily rate or fee, and the business will have to pay employers national insurance, another cost. And the reason for doing this is that businesses are facing the risk of large fines from HMRC if they don't. The factors that are considered are the same for determining workers, whether someone's a worker. So control, mutuality of obligation, personal services, and some other factors like invoicing, whether an individual has an email address for your company, whether they have a title within the company, whether they use your equipment. Now, the government provided on HMRC's website a test called CEST, which is available to you in order to check whether anybody working for you should really be treated as an employee. And that's been refined. At the start, it was quite clunky, and we found that anybody who didn't have a right of substitution was automatically considered an employee for tax purposes. But it has been much improved. And the government has said that if the right, correct information has been fed into that test, they will respect the outcome. So the government will tell you whether you have to treat your workers or your contractors as employees or self-employed for tax purposes. For the individuals, it's advantageous to remain a self-employed individual. And that's why many of them are appealing. And we're seeing quite a lot of pushback for the businesses in which we're working, financial services particularly. So if there is one takeaway for you from today, it's that whilst you're dealing with the health and safety implications of the return to work, don't lose sight of the implications of the Uber decision for your business. Oftentimes, when relationships are working well, it's irrelevant. But it's when the relationships break down that individuals are starting to bring claims to say, I should have been treated as a worker. I should have had paid holiday for many years. I should have had the minimum wage. And they may even say, well, really, I was an employee. I sat next to an employee. I worked like an employee. I attended staff meetings and events like an employee. And therefore, I should have redundancy pay and a minimum notice period, or even to have not been unfairly dismissed. So thank you very, very much to everybody who's given of their time this lovely sunny day. We're happy to take any questions, and thank you again to the Spanish Chamber for allowing us to speak to you this morning. Sorry, just one more thing. There is more information on our hub, the Coronavirus Hub, available on our website, where we talk through the topical issues, vaccinations, how to deal with staff pushback, all of those sorts of topics, and broader topics to talk about your business and how you can react and obtain loans and support. So please do check that out. Thanks, Hannah.
Brilliant. Thank you very much, both Melanie and Ned. A lot of really very useful and topical information in there. So yeah, as Melanie just mentioned, we've got some time now. And if any of you have any follow-up questions from what they spoke about, please do write them in. So you have, as I mentioned before, there's both the Q&A function or the chat function that I've just wrote in, so you should see where it appears now. Either one of those works fine. Okay, so to kick us off, one question we've had is, can we ask employees to complete a medical questionnaire before coming back to the office?
Melanie, do you want to take that one?
Yes, I think you have to be very clear what the purpose of that is. I think lots of employers are obtaining that information indirectly, either through a questionnaire or through a survey, to find out, about vaccinations and the concerns that employees have about returning. We're seeing a lot of businesses want to obtain further information, but they have to be very careful, because that information is what we call special category data. It used to be sensitive personal data in the legal language. And the business can only obtain that for a legitimate purpose with the consent of individuals, and only use it for very specific reasons, which it's making clear. So I think on the whole, I would say it isn't wise to do a blanket questionnaire about health. I think it is fair to ask anonymized questions. And I also think that if people have specific concerns, it's fair enough for line managers to talk to those individuals. But I think I would be very wary about a blanket questionnaire. I'm just not sure how that moves you forward.
Agreed. I think just to add on that, under the GDPR rules, because it's sensitive personal data, you'd be required to carry out a data protection impact assessment before conducting anything, and so you need to have some thorough procedures in place to really explain to employees why you are carrying out the exercise.
Fair enough, thank you, that makes sense. Okay, another question we've had is, can we ask employees upon their return to work to consider their outside work interactions before working on site? For example, if they attend a large internal gathering and surges in numbers begin again, can we ask employees to use their own personal sense to suggest they work from home to minimise risk to colleagues for a few days?
Yes, I think you can. We are all individually responsible for our health and safety and the health and safety of our colleagues. And it would seem artificial to look at an individual when they're at work and not ask them to consider their outside of work situation. We are being asked as employers to consider those circumstances in terms of not requiring people who've got vulnerable connections or childcare to be put in a situation which could cause a risk to a third party. So you're doing the reverse. You're taking into account, or asking them to take into account, those wider circumstances so that it doesn't impact on their colleagues at work. I think that's legitimate. I think you've got to be careful about how you take action if staff don't do it. So if somebody went to a gathering or a football match or something where they could potentially have increased their risk, I think you've got to be very careful about taking disciplinary action because it's outside of work. But I think you can certainly ask and encourage people to make wise choices.
Great, thank you. Another question someone's asked is, where does the liability sit if employees catch coronavirus at work or on their way to work?
I'm not sure what they mean by liability. There isn't a direct claim of I caught coronavirus from work, but I think there is the potential for a personal injury claim if that goes on to cause harm and loss. So I think it would be the employer's responsibility. Responsibility follows if the employer did or left somebody in a situation where there was a risk which was foreseeable and which the employer had not tried to minimise. So all the actions we talked about at the top of the discussion, making sure there's barriers, making sure there are teams, making sure there's sanitizer, making sure people socially distant, use one-way systems, all of those things go a great way to minimising the very small risk that the employer bears here.
Perfect.
I think it'll be very difficult as well for employees to prove who and how they caught the COVID from, and actually trying to blame a fellow employee or employer.
Yeah, fair enough. That's a very good point. Okay, we've just had, at the moment we had a couple more questions, but please do keep writing them in, everyone, if you have any more via the Q&A or the chat, as I mentioned before. You spoke about staggering working hours, for example, and someone's just asked, how do we go about staggering working hours to ensure that not all of our staff are in at the same time?
I think the first thing you have to do is consult and talk to your staff about those who are prepared to vary their working hours. You can say the company is looking at this as an option. What flexibility do you have? Would you be willing to do so? Can we talk to you about it? I don't think any employer should impose a change of working hours. You can't do things like that unilaterally without causing somebody to perhaps resign or raise a concern because it impacts on their working and family life. What you can do as a business is start to talk to staff about how you're doing it within the context of health and safety to try and minimise risks, and ask people if they'd like to volunteer to be in part of a group, perhaps have a pilot group where you start working through this and seeing how it impacts, and then trying to get people on board. So it's persuasion rather than enforcement.
Okay, another one we've had, again, you also spoke, you touched on mental state earlier as well, and so in follow up to that, someone's asked, how can we assess people before they return to the office in terms of their well-being or their mental state more generally?
It's a great question, and it's not an easy thing to do. I think line managers should be encouraged and should have been encouraged throughout the pandemic to have contact regularly with staff members on a team and one-to-one basis to try and support staff and identify if there are risk factors. If there is somebody who is on your team's meeting who always has their camera off, somebody who is normally very well presented, who looks dishevelled, somebody who is not engaging, is not performing, or is doing their work very late at night or very early in the morning, I think those are the sort of indicators that would prompt me to encourage that line manager to have a discussion with the staff member and see how they are. You can only ask the question. There are limits to how far you can intrude in someone's personal life if they're not willing to talk to you about it. But we are certainly seeing a lot of people reporting isolations and depressions and difficulties with motivation and anxiety. And I think open dialogue is a great way for a business to show to individuals that they don't need to be concerned about the workplace and that their business will do what they can reasonably to support them, point them to the employee assistance programme, or perhaps there's a certain thing that HR could be involved in so that they vary a working time or a working arrangement to address a vulnerability.
Thank you. Ed, did you have anything you wanted to add to that, or?
No, I think Melanie covered all bases on that one.
Perfect. Okay, well, the last question we've had for the moment is what should I do if I find out several days later after an employee's been in the workspace that they were diagnosed with COVID-19?
It's a great question, and actually it's happened to a number of our clients. You don't find out immediately necessarily. People may be asymptomatic, so the important thing is immediately you want to make sure that the individual concerned is isolating, pardon me. You want to make sure that they're home and they're safe, and then you need anonymously to notify other members of staff that they may have been in contact. They need to remove themselves from the workplace. They need to get tested. And then you start to have that ripple effect. You need to look at who has had contact, and you need to ensure that they are isolating and tested.
Perfect. Brilliant. Thank you so much. Well, those are all the questions we've had so far, but after this webinar, we'll be circulating around to everyone who's joined both Melanie and Ed's email addresses. So if you have any other follow-up questions or questions about Cripps Pemberton Greenish as well and the services they offer, you can get in touch with them via there. Within that email, I will also be circulating a feedback survey from this webinar, and also the presentation itself, and also the recording of it, which will be on our YouTube channel. So if any of you think this would be useful to a colleague or a contact of yours, please do feel free to share the video with them so more people can see it. Yeah, well, thank you very much, Melanie and Ed. And yeah, it was a very insightful session. We really appreciate your time today.
Very much pleasure.
Thank you very much.
Thank you.
Thanks, Hannah.
Thank you, and thank you everyone for attending.